Ohio versus Isabella Rotondo, cases 25 CR 00085 and 0000581. In this matter, on case number 085, the defendant originally pled guilty on July 14th and was then had filed for intervention in lieu of conviction. Same in case number 25 CR 581. She was referred then for an intervention plan, and then there was a motion to terminate intervention in lieu of conviction filed on December 17th. In this matter, and that alleged several violations, that being of Rule number 8, Rule number 11, Condition 8, Rule number 11, Condition 7, and Rule number 11, Condition 4. We were last here for purposes of a probable cause hearing. It's the state's understanding today that the defendant would waive the right to have a final hearing and proceed to a change of plea in this matter. She is present today with her counsel, Mr. John Fatica.
Thank you. Mr. Fatica, is that correct? What is the defendant's intention at this time regarding the final hearing on the motion to terminate intervention in lieu of conviction?
Good morning, Your Honor. That is correct. We'd like to waive the final hearing, accept responsibility, and resolve the violations today.
Thank you. Cindy, both PVs are the same, just one was with a warrant, one was without a warrant, right?
Yes, sir.
Okay. Well, Ms. Rotondo, you have been charged with violating the conditions of your intervention plan that were originally put in place back on July 14th of this last year. Specifically, it's alleged you violated 4 separate rules or conditions. The first is Rule 8, which requires you, or should say prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged you admitted to using Suboxone on December 10th, that you admitted to using Suboxone on a prior date. It's further alleged 3 violations of Rule 11. Rule 11 requires you to comply with all special conditions that are set forth by the court. The first special condition was condition number 8, which required you to attend grief counseling. You had not done that at all. Second special condition was number 7, which required you to resolve all outstanding warrants. You had not done that. And the third special condition was that you attend 3 AA meetings a week and obtain a sponsor, and you had not been attending 3 AA meetings a week. Now, you have the right to have a final hearing regarding these allegations. That's a hearing where the state of Ohio would have to prove the actual merits of what they're alleging with these violations. Now, you can have that hearing, but you can also waive the hearing and plead guilty to the violations. And it's my understanding, based on what your lawyer had just indicated, that that is your desires to waive the hearings and plead guilty to the violations. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact, or I should say your intervention plan, if in fact that did occur, the court would lift or vacate the stay of criminal proceedings that were initially ordered by the court. I would find you guilty of the charges in each of these 2 cases, and then we would proceed to sentencing in each of the 2 cases. And in case 25 CR 085, you pled guilty to 2 felonies of the 5th degree, so you could be sentenced up to a maximum of 2 years in prison, fined up to $5,000. It's also a probationable offense that you can be put on probation for up to 5 years with a variety of different conditions that you follow. In case 25 CR 581, you pled guilty to 1 felony of the 5th degree. That would be punishable by a maximum prison term of 12 months in prison, $2,500 fine. It also is probationable as well. So do you understand the potential penalties and the consequences that you face if you are found to have violated your intervention plan?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have a final hearing, or do you want to waive the hearing in both cases and plead guilty to the violations?
We'll waive the hearing in both cases and plead guilty.
Very well, then, as the allegation that you violated Rule 8 by using Suboxone, what is your plea to that?
Guilty.
As the allegation that you violated Rule 11, Condition 8 by not attending grief counseling, what is your plea to that?
Guilty.
As to the allegation you violated Rule 11, Condition 7 by not resolving outstanding arrest warrants, what is your plea to that?
Guilty.
And as to the allegation you violated Rule 11, Condition 4 by not attending 3 AA meetings a week, what is your plea to that?
Guilty.
Right, the court will accept your pleas of guilty, find that you did violate the conditions of the intervention plan that was imposed in both of these cases. At this time, the court is going to lift the stay of criminal proceedings. I'm going to find the defendant guilty in case 25 CR 581 of count 1, possession of fentanyl-related compound of felony of the 5th degree, in violation of 292511 of the revised code. Case 25 CR 085, I'm going to lift the stay of criminal proceedings as well. Find the defendant guilty of count 1, possession of heroin, a felony of the 5th degree in violation of 292511 of the revised code, as well as count 2, possession of a fentanyl-related compound, a felony of the 5th degree in violation of 292511 of the revised code. The court already has a pre-sentence report and investigation, drug and alcohol evaluation. So, Mr. Fatika, is there any reason not to go forward with sentencing in both of these cases?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Ms. Rotundo has been at the Lake County Jail for 36 days as of today. As you may recall, at the first hearing, she was in a wheelchair. She is making progress. I met with her last week. She's seems to be thinking much more clearly. She's not had an opportunity to participate in residential treatment. That's what we're asking for today. She's been in medical isolation at the jail for this 36-day period. It's been rough on her. She's been going through some very harsh withdrawal symptoms. But again, we would ask that she be given an opportunity to participate in residential treatment.
Thank you. Mr. Rotundo, you have the right to address this court before your sentence, and you can say anything you like. Is there anything you'd like to say in either of these cases before sentencing?
I would like to apologize and take full accountability and ask for the opportunity to get residential treatment so I could get back on track and do well and be there with my child and just do things right. And I'm sorry for letting everybody down, and I just apologize. I apologize.
How are you feeling now?
I'm feeling better. I'm just feeling upset. I'm just disappointed in myself, and I apologize.
I get that, but I'm talking, not that I'm not interested, but it's just on physically, your physical health, how is that going?
Physical health?
I mean, I don't want you to divulge anything you don't want to divulge.
No, it's okay. The physical health, it's been hard. It's been really hard, especially being on the lockdown and everything, and I saw a nurse.
That's because of medical issues?
Yeah, medical issue. Yeah, and they haven't cleared me yet for that, and it's been, like you said, 36 days in a medical lockdown, so I'm trying to figure that out and get off of that because it's not, you know what I mean, helping anything per se. But I'm trying. That's all I can do. That's all I can do.
Okay. Mr. Fatika, is there anything else that you want to say?
No, thank you, Your Honor.
Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, what we discussed in chambers we feel would be appropriate with residential treatment. She does have on case number 085, 38 total days, 36 on the PV, and then on 581, 31 total days, 27 on the PV.
Thank you. Well, the court reviewed the original pre-sentence report and investigation, the drug and alcohol evaluation. I considered the facts and circumstances of the offenses involved here, the nature of these offenses. I've also considered what's been said here today. I considered the nature of the violations that brought us back here today as well. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. For the factors in 292912, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes the commission of these offenses. As for recidivism factors, the court notes there is a prior criminal history. So these are our first felony charges. It does appear that the case in 25 CR 085 occurred while she was on probation in the Mentor Municipal Court. They were also committed while she had warrants issued for her for failing to appear in court for traffic offenses. Drug abuse problem obviously relates to the commission of the offense. It seems like, however, the defendant wants to get help and treatment. For recidivism factors, indicating it's less serious, there's no juvenile delinquency adjudications. Criminal conduct didn't start until even, when did she turn 18? Like in 2016. It didn't occur until 6-7 years later. So something happened around that time.
It started as soon as my dad passed away. He passed away in August of 2021, and I got arrested for the first time in December of 2021.
Who's Dustin Dowen?
Dustin Dowen, the father of my child, that just destroyed my life completely.
Well, it seems like maybe there's an issue there as well. But
absolutely.
because I see his name in the very first entry here, and you're not supposed to have any contact with him, and you're still having contact with him.
That's why I'd like to just stay as far away from him as possible and just.
You're going to have to.
Absolutely.
And if you don't, it's going to be a violation because it's going to be an order.
Right.
So, court also finds defendant is amenable to community control sanctions. Prison is not consistent with the purposes and principles of sentencing. Therefore, in each case, the court is going to place the defendant on community control sanctions for 2 years. It'll be 2 years total, so it's a concurrent 2-year community control sanction. Same with the counts in the one case. I'm going to order, in case 25 CR 085, serve 83 days in jail with 38 credit. In case 25 CR 581, you serve 77 days with 31 credit. Leaves 45 days for you to start immediately get into the jail treatment program. Complete that successfully. Follow all aftercare recommendations. Upon completion of that, you are to be released as soon as the bed's available and enter the residential treatment center at either. It's either one we're going to, right, Cindy? Oak House or Nevaeh?
Yes, sir.
Oak House or Nevaeh Ridge. successfully complete that program, follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol, and that includes no medically assisted treatment. We're not doing Suboxone or methadone. Submit random urine screens. They have to be negative. 3 AA meetings a week. Proof of 3 AA meetings a week. Attend them and provide proof. Have a sponsor. Are you able to, I know you've got some issues now, but there's no reason you can't work once you're...
I'm not sure I don't see a reason why, but they still have me on a medical lockdown. I'm not
so
sure.
you're to obtain and maintain full-time employment and or education. If you want to go to school, get some type of training, whatever, you can do that as well. But a full-time basis, once you get out and back on your feet, you should keep yourself busy on a full-time basis, working or going to school or some combination of the two. You have one doctor and one dentist. This is the same conditions that were on the intervention plan that can prescribe you medication. One pharmacy. If you have a specialist, that's fine too, but probation needs to know who the doctors are that give you prescriptions. You can only get them from those doctors. You can only fill them at one pharmacy. They need to know where that is. And to sign whatever releases they need to have you sign so they can speak to those folks or counselors. You're to attend grief counseling. You just even acknowledged here today that's what caused all this. You're not to have any contact with Dustin Dowen, aside from whatever may be ordered by juvenile court or domestic court. If they require that for some type of contact with the child, then that's going to have to happen, just to facilitate that. Otherwise, no contact. And no contact means no contact. Not just face-to-face talking. It means emails, messages, phone calls, messages while you're in jail.
Okay.
It means not having anyone else have contact that you're directing to have contact. You can't have your mother reach out to him and say something, or friends contact him.
Okay.
No contact. Pay court costs and supervision fees. Take all medications as prescribed. Stanley, anything else that I'm missing here I should think about?
Your Honor, would you like her to continue to pursue resolving those warrants?
Oh, yeah, absolutely. Those need to get resolved. I mean, I know you can't do it right now, and you're not going to be able to do it maybe, but you can't be on probation and have warrants out for you. So those need to get resolved, and however they get resolved, they get resolved. It's not going to impact your probation. If you feel it's in your best interest to plead guilty to those outstanding, if there even are charged, I think they're traffic, then you do that. That's not going to affect your probation.
Okay.
You do what's ever in your best interest in those.
Okay.
Anything else, Cindy? I'm sorry.
No, Your Honor.
So do you understand all the conditions of your community control sanctions?
Yes, Your
Any
Honor.
questions for me?
No, Your Honor.
All right, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit a new offense from this day forward, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison. If I did that, in case 25 CR 085, it'd be 12 months on each count consecutive for 24 months in prison. In case 25 CR 581, it would be 12 months in prison. The two cases would be consecutive to each other, so it's 3 years in prison that's hanging over your head. You understand that?
Yes, Your Honor.
All right. And any prison terms that would get imposed for violating post-release control could be consecutive to any other prison term that you may be serving if there's some other case out there, or that you're being sentenced to if there's something new that happens. You understand that?
Yes, Your Honor.
Okay. Ms. Linden, anything else for the record?
No, Your Honor,
I
thank
have a
you.
question.
Mr. Fatika?
No, thank you, Your Honor.
All right, thank you.
All right.
before you this morning is case number 25 CR 611, captioned State of Ohio versus Carmen A. Palladino. Judge, the Lake County Grand Jury indicted the defendant on November 7th of 2025 with one count. That was a charge of telecommunications harassment, a felony of the 5th degree in violation of ORC 2917-21A5. The defendant is present today in court with his counsel, Ms. Tomasic. It's the state's understanding that he wishes to withdraw a formally entered plea of not guilty and plead guilty as charged in the indictment, judge, to that one count of telecommunications harassment, a felony of the 5th degree. Should that plea be forthcoming, it's the state's understanding the defense will ask for a pre-sentence investigation into the matter. And I don't believe we have a joint recommendation. We do have a joint.
I don't believe we do, no.
We didn't discuss that.
Correct.
I didn't note it, so yeah. So there is no joint recommendation when we next appear for sentence, Judge.
Thank you. One second, please. All right, Ms. Thomas, does that all sound accurate?
Yes, Your Honor.
And Mr. Palladino, were you able to hear what the prosecutor just had to say regarding what she believes your plans are here today?
Yes.
She indicated to the court she believes it's your desire, excuse me, to withdraw your previously entered plea of not guilty and plead guilty to the charge in this indictment. I'll go over that with you to make sure you understand that. We would then defer sentencing to a later day. Get some reports completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here then. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you, sir?
37?
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
Not at all.
What about within the last 48 hours?
Nope.
Not even prescribed medication, nothing?
I'm prescribed Seroquel, 25 milligrams. I took that last night.
Okay. Anything else?
No, that's it.
Excuse me. Does the Seroquel that you took last evening in any way affect your ability to understand or appreciate where you are, what's going on, or cloud your judgment in any way?
No.
Okay.
No.
Okay. Now, you would have received a copy of this indictment. Looks like you've got it sometime back around middle of November about, which is the document that sets forth the charge you're accused of committing and what you're pleading guilty to. You remember getting that?
Yes.
And at some point you had a chance to look that over?
I did, yes.
Now, in that indictment, you are charged with one count. And what is alleged here and what you'll be admitting to is on or about April 21st, 2025 in Mentor Lake County, Ohio, that you didn't knowingly make or cause to be made a telecommunication or knowingly permit a telecommunication to be made from a telecommunications device under your control to another person, and the caller knowingly made the telecommunication to Alexis Hyam, the recipient of the telecommunication, to another person at the premises to which the telecommunication is made or to those premises, and the recipient or any other person at those premises previously had told you not to make a telecommunication to those premises to any person in those premises. It's further alleged you have previously been convicted of telecommunications fraud in the Willoughby Municipal Court back on March 21st, 2023. What is telecommunications fraud? Gosh.
What's that?
So what is telecommunications
This
fraud?
section, Judge?
Hang on a second. Just turn my computer off by mistake. See counsel in chambers.
All rise.
Sit down. Do they normally do that?
Once in a while.
Okay. Okay. I got.
Move to amend the second paragraph in the indictment under count 1 to read that the said Carmen A. Palladino had previously been convicted of telecommunication harassment, inserted in place of the word.
What else does it say there?
To it in the Willoughby Municipal Court case number 23 CRB 00085 dated March 21st, 2023. Upon review of the actual judgment entry of conviction judge in the Willoughby Municipal Court, the count in the actual entry is telecommunications harassment. The indictment does reflect the correct case number and the correct date of conviction.
I'm going to grant that amendment as much as the indictment references that correct that specific case number and date of conviction, which coincide with the offense of telecommunications harassment. I will allow that amendment. So, Mr. Palladino, give me 1 second. My computer had turned off. Can you give me then a copy of that indictment? Just get from Mr. Nero. Do you have it, please? All right, so Mr. Palladino, I'm going to review this with you again, the indictment. What's alleged here and what you'll be admitting to is on or about April 21st, 2025 in Mentor Lake County, Ohio, that you do knowingly make or cause to be made a telecommunication or you knowingly permitted a telecommunication to be made from a telecommunications device under your control to another person, and that you knowingly made the telecommunications to Alexis Hyam, the recipient of the telecommunication, or to another person at the premises to which the telecommunications is made, or to those premises, and that the recipient or any other person at those premises previously had told you not to make a telecommunication to those premises or to any of the persons at those premises. It's further alleged that you have previously been convicted of telecommunications harassment. That was in the Willoughby Municipal Court, case 23 CRB 00085 on March 21st of 23. That conduct with the prior conviction constitutes the offense of telecommunications harassment, and it is a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 here?
Yes.
Any questions for me about it?
No.
Well, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up before you enter your plea. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial, and that will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. Unanimous means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of the charge, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when you speak about this burden of proof, since it's a criminal case we're dealing with, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of that charge at a trial. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial.
Yes.
Now, in order to try to do that, if we were having a trial in this case, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You'd call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Mm-hmm. Yes.
And you further can request the court issue an order. We call that order a subpoena. And what a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if you went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
As far as sentencing goes, you're pleading guilty to a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, no.
Sorry?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence is imposed in this case, upon your release from prison, you could be put on what is called post-release control. We sometimes call that parole. That's a period of supervision you would be on after you completed whatever prison sentence, if any, was imposed. And in this case, it could be up to 2 years. Do you understand that?
Yes.
And if you are on post-release control and are violating any of the conditions of your supervision, parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 9 months, or 50% of the prison term originally imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there's other sanctions I could order. I could fine you up to $2,500. I could order that you pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
I could also order that you pay restitution, if that's applicable, to the victim for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
I could also order a no-contact order in this case, and order that you have no contact with the victim in this case. You understand that?
Yes.
Now, if you are put on probation, well, strike that. A few moments ago, I told you the possible prison sentence. When I told you that, I used the word possible because prison's not mandatory. You're eligible for probation, or what's called community control sanctions. Do you understand that?
Yes.
You understand just because you're eligible doesn't mean it'll be automatic. It means I'll consider that if that's what you're requesting. I'll look at all the information presented, then I'll make the decision I believe is the right thing to do. Do you understand that?
Yes.
Now, if you were put on community control sanctions, it could be up to 5 years of supervision. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you're on probation in this court and you violate any of the conditions, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 6 to 12 months, and that could be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes.
All right, lastly, when we come back here for sentencing, you'll have the right on that day to say anything you want, anything you want me to know or consider. Your lawyer could speak on your behalf and recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand all that?
Yes.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along with that or follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No.
You understand all
no.
the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer, have her review the report with you, discuss the issues, answer your questions?
Yes.
You satisfied with her advice and counsel?
Yes.
Has she or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this time regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, the only question is, what happens if I get sentenced for probation? Is it a full 5 years or?
Could be up to 5 years.
Up
So
to
it could be
5
1 year,
years? All right.
or 18 months, 3 years, 2 years.
All right.
The average probation, I'm not going to say this is what you're going to get, but typically, if I put someone on community control sanctions, it's for at least 2 years. Usually, maybe
Okay.
2 to 3 years. Usually, somewhere in that range.
All right. That's it. That's all I got.
Do you need any more time to talk to your lawyer? before we go forward with the actual plea?
No.
What we're going to do at this time is the prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'll have some follow-up questions for you, all right?
All right.
Ms. Naroda?
Thank you, Judge. Had the state proceeded to trial in this matter, the state would have brought forth the following facts that support the charge that the court has already outlined in this matter. And that was on April 21st of 2025, Officer Trader of the Mentor Police Department responded to the residence of Alexis Hyam. The reason for the response was the victim reported that she was receiving repetitive calls from the defendant that started out as the defendant attempting to make inquiry about their child, and then it became aggressive arguments and voicemails were left, and she wished to pursue charges concerning that. The officer took the report, called the defendant, advised him not to call Ms. Hyam anymore. And approximately an hour later, Ms. Hyam again called the Mentor Police Department. Officer Trader responded, and she was on the phone there was an active call, and it was the defendant talking. The officer took the phone and again advised him not to call, and the call was disconnected. And as the state has previously discussed, the defendant does have a prior conviction for telecommunication harassment in case 23 CRB 85 dated March 21st of 2023.
Thank you. Mr. Palladino, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we did, in fact, have a trial?
Yeah, I heard what she said, yes.
Well, what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Those facts are not true at all, not one bit. The reason why the police officer was there in the beginning was because somebody called, her mother called for a welfare check on my kid's mother because she wasn't answering the phone. So that's the reason she was initially there. While she was there, I was calling. Then she stated not to call. The police officer stated to me. And then she was still there, I think, the whole entire time. It wasn't no hour. It was about maybe like 15 minutes. I called back, and then she gave the phone to the police officer, and the police officer was like, I'm going to charge you with this and that.
So you were told not to call back. You did call back.
Yes. I mean, that's what it boils down to, but...
That's what you're charged with doing. You were advised not to call there anymore, and you called back after you were advised that. Is that correct?
Yeah, that's correct. That part's correct.
That's all I care about.
But
in terms of why someone was there, I don't care about that.
I
You're charged with knowingly making a phone call to Ms. Hyam after you were told not to make any more calls to her. You did that.
yes.
Very well then, regarding count one, charging with telecommunications harassment, felony of the 5th degree, what is your plea to that?
I mean, guilty.
All right, I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth what I just explained to you about all the rights and penalties you face. Before I can accept your plea, I need to make sure you understand the document and that you sign it here in open court. My understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes.
Now, the only thing I changed on this document, just so you know, on the second page it reads, I'm not under the influence of drugs or alcohol. I'm not taking any drugs or alcohol in a 48-hour period preceding this hearing. I inserted the words except for Seroquel last night, because that's what you told me.
Okay.
Otherwise, it's identical to what you previously saw. So you had a chance to go over this before? Ms. Tomasic, is that accurate? Did you review this with your client?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, he did, Your Honor.
Is that correct, Mr. Palladino? You understand what the document says?
Yes.
Do you have any questions for me about that?
No.
It also appears you signed the document. Did you sign it?
Yes.
You witnessed that, Ms. Tomasic?
Yes, Your Honor.
Ms. Naroda, you as well?
Yes, Judge.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. I sneeze. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, telecommunications harassment, a felony of the 5th degree in violation of 2917.21. Hold the first sentencing, order a pre-sentence report and investigation, victim impact statement. Continue bond and own recognizance with the condition that you have no contact with the victim in any manner. That means phone calls, emails, text messages, going to her house. You can't cause someone else to have contact with her as well. You can't have someone else reach out to her to ask her something or tell her something. And it doesn't matter if she initiates it. You understand that?
Yes.
Is there anything else you're requesting?
No, Your Honor.
I do got a question
You have a question for me or your lawyer?
for you.
Go ahead.
So I talked to my 2 kids. Is that fine? Like, they have their own phones.
Yeah, as long as you're not talking to her or telling your kids to tell mom something, tell mom this or tell mom that.
Yeah.
You're allowed to talk to your kids.
All right.
As long as you're allowed to. I mean, is there some other order out there that
No.
I'm not aware of? I don't know that.
No. I'm just saying I don't want to.
No, you're allowed. If they have their own phones, you're allowed to do that. If she were to answer the phone, you need to hang up.
All right.
You can't have her be put on the phone. You can't tell your kids to tell mom this.
All right.
Now, your bond is being continued at own recognizance. I explained what this means before in the past, but I'll explain it again. It means you have to show up at all future court dates. Your next court date is the sentencing, which is when, Stan?
March 2nd, 2 o'clock.
March 2nd at 2 o'clock. So if you need to be here then. If you're not here, that'd be a separate felony you can be prosecuted for.
All right.
Now, I'm referring this for a pre-sentence report, which is a report the probation department puts together for my benefit. Tells me about your background and everything. The way they get the information they need to prepare the report is they have to conduct an interview with you. It's important that when you meet with them that you're open and honest with them because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I'll consider that at sentencing.
All right.
One of the conditions of your bond also is that you don't use any drugs. You have to submit urine screens. If requested, they have to be negative. Positive screen will be a violation. You understand that?
Mm-hmm.
So you're going to leave here now. You're going to go right over to the probation department, fill out some initial paperwork, and get your date to come back for the interview. So make sure you go there now, and make sure you go there when you're supposed to when you set that date.
All right.
All right? Any questions?
Nope.
Ms. Tomasic, anything else?
No, Your Honor. Thank you.
Ms. Naroda for the state.
Nothing further, Judge.
All right, thank you. Stan, can you get
morning, Your Honor. We are hearing case 25 CR 318, State of Ohio versus Claude L. Bernard. Present in court is the defendant, who is accompanied by his attorney, Mr. William Watson. We were previously here on December 30th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, possession of cocaine, a felony of the 3rd degree, and count 4, possession of marijuana, a felony of the 5th degree, both of which had attached forfeiture specifications. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report that has been completed. The state's had an opportunity to review that report and is ready to proceed with sentencing. The state would move to dismiss the remaining counts of the indictment, and there are 4 days of jail time credit. Thank you, Your Honor.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. I know we had a brief discussion in chambers, but Mr. Bernard is a gentleman with some problems. He's got a history. He's been to prison before, and he's currently serving a prison sentence, I believe, out of Ashtabula County. Your Honor, he knows that he's made a lot of mistakes in life. He knows that he's gone down the wrong path, and he's paying for it right now. And I've talked to Mr. Bernard several times since he's been brought over for this case, and he's expressed to me that his desire to use his time wisely, which currently I believe is over 2 years in prison, not to mention what this court may impose, so he's got some time ahead of him, but ultimately he's going to get out one day, and he's expressed to me that he's going to use his time wisely, so when he gets out, he never goes back. He wants to turn his life around. He wants to focus on a trade, get some skills so he can get into a job when that day comes. Your Honor, with regards to the mandatory fine in this case, I do have a signed affidavit of indigency. I will be filing that as soon as this is completed. I did let Ms. Himmeline know about that as well. I'm going to ask the court to take that into consideration, and I'm going to respectfully ask the court to just impose and fashion a reasonable sentence in this case. Thank you, Your Honor.
Mr. Bernard, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say?
Yes, Your Honor. I understand there's not many things I could say, nothing I could say to justify my actions that brought us here today. I know they were unacceptable, and I just pray that the courts afford me the opportunity to get out there and take advantage of the opportunities that lay ahead of me sooner rather than later. I know I have some major changes that need to be made, and I plan on taking advantage of that as soon as possible.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Himmeline for the State of Ohio.
Thank you, Your Honor. The state would recommend that the court impose a prison sentence in this case to run consecutive with the current prison sentence that the defendant is serving. He does have a lengthy criminal history, including juvenile adjudications and a lengthy adult history. He's had a number of probation violations in the past and multiple prior prison sentences. And so for those reasons, the state does recommend prison consecutive to the current sentence. Thank you.
Well, this court reviewed the updated abbreviated pre-sentence report and a prior pre-sentence report from some years ago as well. I've considered the facts and circumstances of this offense, the nature of this offense. I've considered what's been said here in court by Mr. Watson, the defendant himself, the prosecutor. All this is considered under the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, nothing's present indicating it's more or less serious. For recidivism factors, the court notes the defendant has an extensive criminal history, has previously served a prison term, was on probation when this happened, not on probation, on bond to another court when this happened. No factors indicate recidivism is less likely. There's a presumption for prison. Presumption has not been overcome. Defendant is currently serving a prison sentence for a fleeing and eluding charge out of, I think, Ashtabula County, right? Yeah. Defendant is not amenable to available community control sanctions in prison is consistent. Therefore, will be the sentence of this court. Then on count 1, defendant served a term in prison of 18 months. On count 4, served a term in prison of 11 months. I'll run those two counts concurrent with each other. But by statute, 29-21.331, that must be consecutive. to the sentence he's currently serving, as the sentence he's currently serving is for a failure to comply charge out of Ashtabula County. He has credit for, did you say 4 days?
That's correct.
4 days, I'll get that credit. I'm going to order the forfeiture of the contraband and instrumentalities. Do you have, I don't need it on the record, do you have the Ashtabula case number so you can put that in the entry? Or you can get it?
I do have it,
Okay.
yes.
Make sure that's in the entry. Need to advise you upon your release, you could be put on post-release control for this case up to 2 years. If you are and you violate any of your conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court disapproves the defendant's placement in a prone of shock incarceration intensive prison program, transfer to transitional control, and defendant's ordered to pay all costs. The mandatory fine of $5,000 will be waived upon the filing of the affidavit of indigency. The remaining counts of the indictment will be dismissed as agreed upon. Is there anything else for the record, Ms. Himmeline?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right, thank you. Good luck.
the risperidone because the Invega Sustenna is a corollary medication that you can give once a month as a long-acting injectable in order to help people to stay stable, even if they're not taking oral medications. And he does have a historical pattern as documented in his jail records, as well as after the codes and the emergent episodes of medication here at the hospital, of responding positively for a brief period of time after an atypical antipsychotic dose, such as Zyprexa.
Okay, so that was going to be my next question. Historically, Mr. Harris has taken